State University College of Medicine to the extent of interfering in the affairs of the College of Medicine to the detriment of the effective functioning of the Lagos State University College of Medicine, of which the claimant is the administrative head. 2, a declaration that the findings and recommendations contained in the report of the audit review of the financial activity of the Lagos State University of Medicine spanning January 2016 through October 2017 submitted to the Vice Chancellor, which is the first defendant by the Lagos State University Ojo, Directorate of Internal Audit in November 2017, is unconstitutional, null and void, and of no effect whatsoever, as the claimant was denied his right to fair hearing by the Director of Internal Audit before the findings and recommendations were made, contrary to Section 36(1) of the Constitution of the Federal Republic of Nigeria, 1999, as amended. 3, declaration that decision of the Finance and General Purposes Committee. Gentlemen, let me save you the trouble of going through all the reliefs there. 17 reliefs as contained in the process, right? I'll save you the trouble of going through the individual reliefs.
As your lordship, please.
Yeah, the defendant entered appearance and with the leave of the Honorable Court filed their consequential amended statement of defense dated 6th of November 2018. At trial, the claimant testified as CW. He adopted his deposition on oath. 42 documents were attended by documents admitted into evidence as Exhibit C1 to C21 and Exhibit C21 to claimant was cross-examined and thereafter discharged. The claimant then closed his case. The defendants opened their case. Ankorban David Semewon Ogumbe, Principal Assistant Register last who testified as DW. The adopted his sworn deposition on oath of 4 documents were attended by DW and admitted into evidence as Exhibits D1 to D4. DW was cross-examined and thereafter discharged. Defendants then closed their case. Parties were then ordered to file and exchange their respective final addresses. Now, I've summarized the case before the court. I've also made a summary of the defendant's submissions and final address, claimant's submissions and final address, as well as the reply on points of law. What is of particular interest to parties will be the decision portion of the judgment, which I'm going straight to that. Your summary, this is a judgment that spans almost 40 pages. So I'm going straight to the court's decision now. I'll start off with the resolution of some preliminary issues raised by the parties in their respective final addresses. The defendants had formulated 4 issues for the court's determination in the defendant's final address. Issue 1 for the defendant is whether the claimant is entitled to relief sought before this honorable court following his failure to explore and exhaust the internal/local procedure for resolving disciplinary issues provided by the enabling law that governs the Lagos State University and conditions of service for senior staff that governs the relationship between the claimant and his employers, the Lagos State University. While the learned counsel for the defendants proffered arguments on this issue, the claimant contended that this issue cannot be revisited as the ruling of this honorable court, Quorum Amaoji J, on the 11th day of July 2018 had effectively resolved this issue and there was an appeal pending against this decision. I've carefully considered the ruling of 11th of July 2018 and I find it a bit perplexing that the defendants are inviting this court to review or overrule that decision. No matter how the defendants couch their issue 1, this court cannot revisit the issue of whether or not the claimant was obliged to or had exhausted the internal mechanism for dispute resolution at the Lagos State University. His Lordship Amaoji J had in the considered ruling of 11th of July 2018 held that, and I quote, I find from a critical consideration of this chapter that the defendant had not complied with their own internal mechanism. The claimant had not gone through the Joint Council Senate Disciplinary Committee before the report was adopted and forwarded to the council, which should be the last stage of the process. Having already gotten up to the council without being heard and his response dealt with, the defendants cannot raise the issue that the claimant had not gone before the Joint Committee of the Council and Senate, which should have heard him earlier in the process. The defendant did not show at this stage that the claimant would face the suggested Joint Committee of the Council and Senate as provided for by Section 25(1)(a) of the Lagos State University law following the procedure they already adopted, and the fact that the matter had been scheduled and sent to the council. Based on this, I find that the entire remedy provided by the university had been exhausted and the claimant could approach the court to ventilate any perceived wrong. His Lordship continued. For the avoidance of doubt, the court holds as follows. 1, the notice of preliminary objection fails as it is found that there is no local remedy for the claimant to access. 2, that this court therefore assumes jurisdiction to hear the case on the merits. 2, The first application for interlocutory injunction fails as it grants the tantamount to concluding this substantive suit, and 3, the second application succeeds, ruling is entered accordingly, end quote. I must reiterate that this court cannot review the ruling of 11th of July 2018. The decision stands unless overturned. See the case of Saro and another versus Suswam, citation provided, while his lordship Mbaba JCA held as follows. I'm quoting his lordship now. This is because the decision or the order of the superior court handed down to the lower court remains valid and binding, commanding obedience as long as it has not been discharged or set aside by a competent court. This is a long-cherished legal tradition founded on the principle of bindingness of judicial decisions, rule of law, and judicial precedent. The authorities on this are replete. See the case of Rosek and ATB, citation provided where Wundari JCA maintained that the court judgment remains binding unless set aside by a competent court, and there's always a presumption of correctness in favor of the court's judgment, and until that presumption is reported and the judgment set aside, it subsists and must be obeyed, irrespective of the perception that it is null and void. See also Odogu and Odogu, Labour Party and INEC, where to say that it is firmly settled that a court order must be obeyed, even if such an order is perverse, until such a time the order is set aside by a competent court. See also Alak Bemi versus Fasan Madi, citation provided and I end quote. The above authority is applicably here and binding on this court. I cannot here, under the guise of pronouncing upon all issues delving into issues already decided by a competent court, I therefore resolve the defendant's issue 1 and the claimant's own issue 1 against the defendant, and find that the claimant had, by the ruling of 11th of July 2018, the claimant had exhausted the internal mechanisms of the then Lagos State University prior to filing of this action and as a whole. I now proceed to the objection raised by the claimant in paragraphs 4.69 to 4.79 of the claimant's final address, to the fact that the deposition of DW1 Davis Sema1 Ogumbe was in contravention of the Oaths Act and the Evidence Act 2011, as it was not signed in the presence of the Commissioner for Oaths. The records of the court show that DW1, under cross-examination by the learned senior counsel to the claimant, has stated on the 23rd of November 2022, 23rd of February, I beg your pardon, 2022, that, and I quote, the witness deposition of 6/11/2018 is shown to the witness. Yes, it was signed in my lawyer's office, end quote. The DW1's deposition under cross-examination is further proof. See EcoBank was Norgay Jalingo LGC, citation provided. Now, let us look for the claimant strongly contending in paragraph 2.13 of his reply and points of law that DW1 mistakenly said he deposed to his witness statement on oath in the defendant counsel's chambers while responding to a leading question from claimant counsel. Here, with respect to the learned senior counsel for the defendants, he cannot testify in his address or supply information that DW1 was mistaken his testimony under cross-examination. DW1 never said he was mistaken while testifying. So where's the new information coming from? The deposition of 6/11/2018 was shown to DW1 before he answered the question. I have no doubt that DW1 knew exactly what he was answering, and the leading question or not, which in any case is allowed under cross-examination. This is not a question of oral evidence being used to prove or discredit a document, and the authority of Namayi versus Akoti supra-cited by defendant counsel does not apply here. There's no dispute as to the contents of the document, which is DW1's deposition on oath, but the only issue is as to whether or not the law was complied with and correct procedure followed in making the document. There is uncontradicted evidence that the DW1 signed his deposition in the defendant's counsel's chambers. The deposition of DW1 therefore had failed. The deposition of DW1 of 6/11/2018 therefore had failed to comply with the provisions of the Oaths Act and the Evidence Act and so forth. Now, in a situation where the witness deposition was not sworn before the Commissioner for Oath, his Lordship Ogunwumiju JCA, now JSC, has succinctly held thus in the case of Iroko and another versus Iroko, citation provided, and I quoted his Lordship extensively here. Where his Lordship said, the impression conferred is that he signed it in chambers of his counsel, but the Commissioner for Oath later attested to it. He simply did not sign in presence of the Commissioner for Oath as required by law. This is a defect in form not envisaged by Section 113 of the Evidence Act 2011. It's a fundamental and statutory error that cannot be waived. Therefore, the witness statement of the respondent dated 9/10/2008 is incompetent and inadmissible. It is hereby expunged for having failed the statutory test of authenticity and admissibility. End quote. This court also referred to the case of Aliu and Bulaki, citation provided. Now, I find that the above authorities apply here and are binding on the court. The DW wants the position of 6/11/2018 is therefore incompetent and will be discountenanced by the court and so on. In addition, the records of the court show that DW1 never adopted the contentious deposition of 6/11/2018. No, he didn't. On the 28th of July 2021, the learned counsel to the defendant informed the court that the matter was for defense and he was ready. The defendant then called DW1, who was affirmed. He testified thus, and I quote, "I'm David Sema1 Ogumbe of the Lagos State University. I recall deposing to a witness statement on oath on the 14/12/17. Recall, 14/12/17, not 6/11/2018. I recognize the document shown to me now as my deposition and I seek to adopt it. The court then ruled the sworn deposition of the witness of 14/12/17 is hereby adopted as evidence in chief." End quote. No other depositions were identified or adopted by DW1 on the 18th of July 2021 when he testified. Learned counsel to the defendants then informed the court that he had concluded examination in chief after DW1 had tendered 4 documents into evidence and they were admitted to evidence by the court as exhibits by the court. DW1 was cross-examined on the 23rd of February 2022 and thereafter discharged. The defendant then closed the case. This is the court's record and it is binding on the parties and on the court itself. See Malam and others was registered trustees of Ipman citation provided. Now, the law is quite clear in this situation. Any deposition that is not adopted in open court is deemed abandoned. See registered trustees of Presbyterian Church of Nigeria versus Kenny, where the court held. In other words, a statement on oath would only be evidence to be used by the court in the determination of the plaintiff's claim if it had been adopted by the person who deposed to it as his testimony during trial. If it is not so adopted, it is deemed abandoned and therefore cannot be examined by the trial judge. This is the exact same scenario with DW1's deposition of 6/11/2018. The court will discountenance it again on this ground and as a whole. However, the evidence elicited through DW in the course of cross-examination after taking an oath in open court is competent and therefore can be relied upon by the court in the resolution of the issues between the parties and as a whole. The court can raise and resolve this issue of the non-deposition of DW1 of 6/11/2018 by virtue of the decision of His Lordship Rodsvival GST, then was in Omo Wajo vs. FRN, citation provided, which is to the effect the necessity of affording the parties a hearing when the judge raises an issue so moto is exempted in any of the 3 instances. A, the issue relates to the court on jurisdiction. B, both parties are or were not aware or ignore the statute which may have a bearing on the case. That is to say, by virtue of statutory provision, the judge is expected to take judicial notice, see Section 17 of the Evidence Act. And C, when on the face of the record, serious questions of fairness of proceedings is evident. I find C, Obolaji Oluodara, mute your mic, please. And Abdulaziz Shakir, please mute your mic. Olorun Tuba Oju, everybody mute your mic. Thank you. Coming to reliefs, the merits of the relief sought here, the claimant here seeks several declarations. Declarations are not made as a matter of course. See the case of Ibrahim and Suleiman, Ilya and another versus Lamo and another, and Misa and Ahmed, citation provided for all these matters. Reliefs 2, 3, 4, 5, and 6 are all hinged on an alleged denial of the claimant's right to fair hearing. Fair hearing is an opportunity to be heard. See Joseph versus First Inland Bank PLC and Onituju and Lekki Concession Company Limited, citation provided for both these matters. Now, DW1 is the position of 14th of December 2017, stated in paragraph 13, 14, and 15. DW1 is the position of 14th of December 2017 in paragraph 13, 14, and 15.
Oh, sorry, Dad. Lactose enzyme, is that for
Mr. Samuel, mute your mic or get off the platform.
Sure.
I beg your pardon, gentlemen, just hold on. If mute your mics, everybody, or I'll ask them to mute everybody's mic.
So you have one.
Sorry for that, gentlemen. Now from the full now DW1 is the position of 14th of December 2017 in paragraphs 13, 14, and 15. Averred that the claimant was given an opportunity to react to the allegations against him before a decision was taken. The claimant was then placed on interdiction. However, under cross-examination, DW stated thus: yes, the audit committee was mandated to make far-reaching recommendations. Yes, it made far-reaching recommendations to the Vice Chancellor. The claimant was not invited to appear before the committee from the initial sitting to his final report. I do not know if some people were invited before the committee. Yes, as at the time he was queried, the claimant was not privy to the recommendations of the committee. End quote. From the foregoing, it can be safely concluded that defendants were in a hurry to indict the claimant. By Section 25(1)(a) of the Lagos State University Law, the steps prescribed in handling cases that the claimants are obviously ignored. By the defendant's own admission under cross-examination, the claimant was not afforded an opportunity to be heard before the audit committee, whose report formed the basis of the defendant's subsequent actions. I therefore have no hesitation in finding that the claimant's constitutional right to fair hearing had been breached by defendants, and so reliefs 2, 3, 4, 5, and 6 therefore succeed and are declared as paid. Coming back to relief 1, the claimant had alleged cogent and compelling evidence that is entitled to this declaration. I've carefully considered the provisions of statutes 10, 15, 4A and B, and 17 of the Lagos State Law Chapter F69 2015, and it is the court's considered opinion that the declaration sought can be made when the powers and duties of the first defendant are considered. The fund therefore succeeds and is granted accordingly. Similarly, I've also considered Section 43J statutes 12, 5, and 9, 13, and 15 of the Lagos State Law, and I find that indeed there's nothing in these particular provisions. Recall, these particular provisions are not going out to anywhere. They confer powers on the first defendant to indict the claimant, limiting the relief to these specific provisions. I find that relief 7 is grantable and is so declared. For relief 8, the claimant based this relief on the ground that the members of the Financial and General Purpose Committee considered the report of the Director of Internal Audit were also members of the Government Council that ratified and approved the recommendation of the FGPC, which the claimant contends is unconstitutional. The first of the claimant here is obviously that the members of the FGPC, who are members of the Governing Council, may not have been objective, but there is no concrete evidence of a lack of objectivity on the part of these members, and they were not the only members of the Governing Council to have sat on these recommendations. I find that no circumstantial evidence of the quality that will convince the court to make this declaration has been placed before the court. Relief 8 is therefore unproven and is hereby dismissed accordingly. Reliefs 9, 10, and 12 are particularly entwined. They're all hinged on whether or not the first defendant could act as he did, which question had been answered in the negative, as the first defendant, as this court finds, lacks the powers to control or direct the Director of Internal Audit to act as he did. The powers of the first defendant are limited to those defined under sections 10(1) and 2 of the Lagos State Law, as amended, and paragraph 3 of the schedule of the said law. I therefore grant reliefs 9, 10, and 12, or 9, 10, and 12, and they are ordered. They are ordered as paid. For relief 11, it also succeeds in the view of this court's decision that the first defendant could not interdict the claimant as he did. It naturally follows that relief 11 is grantable and is so granted and ordered as paid. On the basis of the grant of the previous queries assaulted by the claimant, which are the main claims, I find that reliefs 13, 14, 15, 16, and 17 are auxiliary reliefs being contingent on the grant of the main reliefs. I therefore grant reliefs 13, 14, 15, 16, and 17, and they are hereby ordered as paid. All the terms of this judgment are to comply within 30 days, and parties are to bear the respective costs. Judgment is entered accordingly. Thank you, gentlemen. You would have this decision latest by Wednesday, Thursday, Friday. Pick up with Lara. Thank you for your time. Thank you, Lance. Thank you, Lance, for taking the time. And thank you for your condolence messages. It really meant a lot. We passed through a difficult time that time, hence the delay here. Thank you, gentlemen. Have a good day and enjoy your conference.
Well, thank you, Lordship.
Thank you.
I think the granted some